Greetings and salutations. Welcome back to another instructional episode of the Legal Beagle. Today is part 2 of the series from last week, and I won't waste any more time. We're going to get right into it without further ado. Here's Brandon. Welcome back, Brandon. What do we got for us today?
Well, Gary, we're going to finish. This is part 2 of the previous study where we're going to jump back and forth between philosophical ideas, but we're going to finish out the CDC statutory process and read from a judge that is actually using originalist and textualist rules and procedures to identify correctly the words' meanings. And look, guys, I watched a video today that's probably 7 years old. It was the original video that got Canary Mission coming after me, right? And got me canceled everywhere. It was the Tikkun Olam, right? But I was watching it. I was listening to it today, listening to see how far I've grown, but how much I had correctly even back then. And not letting these linguistic framers shape our reality. And that's what they do at every turn. They water our language down. They manipulate the language, and then they manipulate us, the people. You know, man's a woman, a woman's a man. All this crazy madness stuff. Love is love, right? Well, no, love is kind, but it's also stern. You know, it's not gonna reject reality and affirm somebody's disillusions. But it amazed me as I listened to it and how much I've changed. Is that even back then we fundamentally understood there was something we were missing with the language, and Lord knows that up until this point today, Gary, I feel like I could be an English major, but with what they're teaching the children today, I mean, but nonetheless, that's what we're going to do. We're going to finish this up, and we'll probably have a little 20-minute back and forth between Gary and I at the end, because I don't think we'll have but about 40 minutes of information here. But nonetheless, I've got a little nugget that I'm going to stick in here today that happened just today, and it concerns the Virginia Department of Health. I'm going to show people that it applies to your state laws too, that they are running roughshod over the people's life, liberty, and property through the administrative procedure. And we're gonna show it again today. But nonetheless, with that, Gary, you can share the screen and we'll start off.
Brandon, I think you're just a hate monger. That's what's going on.
I've been down many roads on this journey. And the one thing I will say that with that, I harbor no hate in my heart for any man, but I despise despicable do-gooders and altruistic collectivists and false philanthropists who would try to continue blessing me. Okay, stop. I don't want it. I don't want your blessings anymore. How about that? Just keep your doggone blessings to yourself. I'm going to tell you, just keep them. I don't want them.
They're just trying to keep you safe, Brandon.
Quit blessing me.
Just trying to keep you safe. That's all.
All right. So first, before we begin, we're going to go to the philosophical tenets. We're going to start with Holmes, Pound, Cohen, and a few like John Dewey and things like that. The framers that were behind the Rockefeller, Carnegie foundations, molding public education in the backgrounds, and also molding mainstream academia and changing us from an individualistic jurisprudence built off of John Locke's Second Treatise of Government, Thomas Reed's essays on the human mind, and William Blackstone's commentaries on the laws of England. Okay, so I'll start right here. Ultimately, Holmes, Pound, and Cohen offered fairly intense criticism. When you see the word criticism, you can think critical theorist. Okay, Frankfurt School, this whole German Romanticism. You can't, and you can take it all the way back to Gnosticism and all these other isms. But what they are fundamentally is they reject the natural world and all. It is a complete skepticism, and you can get down to the fundamental layer of that. It's that they can. So if we go into the Jewish interpretation of the Shekinah, they're trying to physically marry the male and the female, right? And that's why we have all this transgenderism out here. Instead of unity inside, which means cleaning the inside of the cup where your expression matches. Total fundamental basics right there, right? That's why the book of James is so important, that that our faith is proved through our works, right? And that we live through the natural world and objective reality, understanding that when we harm another in their life, liberty, and property, we've done criminal actions. So we'll always notice the word skepticism and cynicism and damn dog, you scaring me. Criticism. Okay, always critical. What they're criticizing is Western ideology, which is based on individualism. Okay, they hate it with a passion. They always want to go back to their feudalist state.
The biggest minority there is, the individual.
That's right. It is the smallest minority there is the individual. Fairly intense criticisms of analytical jurisprudence as a final formal theory, striving for a useless quintessence of all systems, and an abstract and deductive conceptualism. You'll remember I said these words in the last study. Like John Commons and John Dewey, they moved quickly towards less formalistic and more sociological explanations of lawmaking and state force. But in the end, the American theorists acknowledged the original contribution of positivism to a critical and progressive theory of law. As Julius Stone put it, it was the Augustinians. Now, if you don't know who the Augustinians is, that's why I highlighted it, right? Because this is going to go to St. Augustus, one of the Catholic deals, but what they had done was institute communism then too. If you go all the way back, all property was public, right? And you were under the iron rule of Rome, okay? Is it any wonder why Catholic charities and Catholic NGOs are not involved in the transgender push and the migrant push? Just saying. It may have different veils and different faces on, and it may look as if it has different degrees of separation. But if you rip the mask off, it's a wolf in sheep clothing.
Coincidence is all.
Yeah. And it was the Augustinians who first washed the law in cynical acid and established a basis for more modern, realistic, and pragmatic jurisprudence. This is Felix S. Cohen. It's a coincidence. The Problems of a Functional Jurisprudence, 1937. Cohen gives some idea of the intellectual breadth of functionalism by including under this rubric Pierce, James, Dewey, Russell, Whitehead, Wittgenstein, Carnot, Weber, Tony. See, for example, John Dewey's Austin's Theory of Sovereignty, 1894. Okay? That's who we're quoting. All right, so we're going to back this up with the good side, the common sense side, the logical, reasonable, and rational. Of all tyrannies, a tyranny, this C.S. Lewis, a tyranny sincerely exercised for the good of its victim may be the most oppressive. It may be better to live under robber barons than under omnipotent moral busybodies. The robber baron's cruelty may sometimes sleep, his cupidity at some point be satiated, but those who torment us for our own good will torment us without end, for they do so with the approval of their own conscience. That's a deep quote right there, okay? It's deep. And I'll add one more in here from Frederick Bastiat. And now that the legislators and do-gooders have so futilely inflicted so many systems upon society, may they finally end where they should have begun. May they reject all systems and try liberty. For liberty is an acknowledgement of faith in God and his works. Okay? What you're up against is amoral systems versus moral systems. So let's get back to that. Hide that ribbon. And can everybody see that, Gary?
Absolutely, yeah.
Okay. So we stopped right here. And let's just do a quick recap. The judge was discussing the statutory construction. Sanitation is limited to property. And we ended on him going to finally talk about the Chevron deference. Okay. This is when I say that if the Supreme Court does not knock down the Chevron deference, it's somebody, one of us, need to challenge it instantly again in some shape, form, or fashion. It has to be brought down because it's going to be the first pillar that knocks down the administrative state.
It's the linchpin to the administrative state, no doubt.
Yeah. And so let's read what the good judge had to say about the Chevron deference. Finally, the government invokes Chevron deference, arguing that even if it is reading of 264A is not the best one. This is what the lawyers were arguing. Okay, understand this, folks. Understand you're going up against a den of vipers that will lie, cheat, and steal. Okay, winning is the only option for them. They have no ethics. They have no morals. These are devils. Okay, the court should adopt it anyway. Document 45 at 26 through 28. Chevron deference requires that courts defer to an agency interpretation of a statute that the agency administers when the statute is ambiguous and the interpretation is reasonable. See the case law. But a court defers only if a statute is ambiguous after the court uses all the traditional tools of statutory construction. General Dynamics Land System Incorporated versus Klein. Supreme Court, 2004. You can attribute that to Scalia, by the way, and Thomas. Okay. And what was the other one? He died. William Rehnquist. Bill Rehnquist. Wasn't the best of them, but he was reasonable. They hated him too. But anyway, a court explaining that deference to an agency statutory interpretation is called for only when the devices of judicial construction have been tried and found to yield no clear sense of congressional intent. A court may not rest on Chevron to avoid rigorous statutory analysis. A court cannot wave the ambiguity flag just because it found the statute impenetrable on first read. As explained above, the statute is not ambiguous. Congress addressed whether the CDC may enact preventive measures that condition the interstate travel of an entire population on adherence to CDC dictates. It may not. So that is the end of the matter. So let's do a little hypothetical right here. What if this case was in an Article 1 court?
The Chevron deference would reign supreme.
Yes, it would. Yes, it would. Yes, it would. Yes, it would.
And that's what's coming up this Sunday, by the way, the difference between James the Patriot's going to talk about court of law versus court at law, which is the administrative court versus the Article 3s. And so, precisely.
Yeah, and they have blended them together, right? But you got to force the court of law. And we see this because every case law that ever comes against us is especially in the Choctaw Indians case, it's the consensual relationship rule is another corporation coming on their property and building a business there. But yet he's applied it to us that because we want to go into public accommodation like it's consensual relation. No, it's not. You're providing a service to us and you're open to the public. So, but nonetheless, with that, I want to discuss, I'll take the time. I'm going to move into what happened today. I'm going to take a little break on the CDC case. So today, my daughter called me and she's like, Dad, this hospital that I'm going to work at is requiring that how'd she put it? Is requiring that I have to have the flu vaccine. I said, no way they're still doing this, right? No way. Yep, she sends me the documentation back. I drop what I'm doing at work. I come home and figure out how I'm going to solve this. But for the lesson today, the point that I want to make is it's the same thing over and over again. It's not a birth certificate. It's not your loss at sea. It's not even your social security number that's the problem. The supremacy clause of the United States government is the Constitution. That is the supreme law of land. Below that is the legislative body. Below that is the administrative courts. And below that is case law. Case law is the weakest. Judicial branch is supposed to be the weakest branch of government. However,
and then ordinances.
Yeah. And you have right now judges legislating from the bench. So they've raised themselves up above the legislature. Okay. big problem with the separations of powers doctrine. Read your Federalist Papers. But nonetheless, so what do I start? Start with statutes and codes and legislative law of Virginia, because where do I begin? So I end up on the CDC website. For Virginia, no statute or regulation requires any hospital to ensure that any employees are vaccinated with influenza vaccine. Note, however, 12 Virginia Admin Code, Section 5, 410, 490, providing that hospitals shall have an infection control committee to periodically evaluate and revise as needed infection control policies, procedures, and techniques for all appropriate phases of hospital operation and service in order to protect patients, employees, and visitors. Okay. So we got techniques and services. These policies shall include, but are not limited to. So this is like a contractual obligation, right? We're getting into contractual terms here. Okay. If we start applying all the rules of statutory construction, they just left this open for interpretation. But that's how administrative code's written. To appropriate employee health screening and immunization, among other things. That would be void ab initio, right? For void for vagueness doctrine. Okay, I'm just telling people right now. There's nothing said here that locks you into anything. However, when I go here and read this, it's about policies, and this is you'll see here Virginia law, administrative code, the Code of Virginia, and look over here to the side. You'll see Constitution of Virginia at the top. Okay. You see it at the top. They know charters, authorities, and then the administrative code, I think went right here. But then you have uncodified acts. But nonetheless, at the top is the Constitution of Virginia. I'd have to go read that to go further. However, what I put this in here for y'all to see is that they are writing laws or statutes, codes. They're not laws. Okay, a law, that which is laid straight, and the individual's rights are absolute. The public's rights are relative. Okay, so let me explain that a little bit for you. In order for the state to come in and restrict the absolute natural God-given rights of the individual, they must have objective facts that they can reasonably articulate that leads them to a suspicion of criminal activity, or in the case of public health, that leads them to believe that you are infected with a disease. Now, for me, public health doctrine just needs to go the way of dodo bird. Okay, but let's speak what's in place now. In order for them to quarantine, isolate you, or force inject you to save everybody, they would have to have what? Material evidence. Okay, they would need material evidence, something they can bring in court. Say, Doc, look at this. But guess what? They'll never have with a virus.
Material evidence.
Never. They'll never have material evidence. They'll have raised antibodies. They'll have all kind of other stuff. They'll never have the virus.
Don't challenge them, Brandon. They'll start getting court orders to take everyone's blood and run it through the process. And
well, if you remember when they asked us to self-quarantine, that's the stupidest. That's why they asked you to self-quarantine. Okay? I mean, just see through the layers of bull crap, folks. Learn to read the law correctly. Learn to put it in its proper place, and understand that Brandon's not flim-flamming you. Gary's not flim-flamming you. Alphonse is not flim-flamming you. If you put the administrative code where it belongs, at your feet, and grasp the totality of how important it is to wield your words as swords, right? And you carry that most potent weapon, sword of thy mouth, right? That's why it's in the Bible that way. Yeah. Then we wield back the power, because these master manipulators. Listen, folks, I'm not gonna make y'all read this whole thing. This can't be law. It's too open. It's too vague. It allows too many implications. Okay. It can't be applied evenly to everyone equally, right? Just can't. So that's where I was today, and I thought it was a cool caveat nugget to put it in there to show you exactly how it will impact your life, my life, and it continues to. So let's scroll back up. We're at the point where the judge is going to attack the sanitation, pest extermination, destruction. We already know that he has denied the Chevron deference. Okay. But this is what now listen, this is 7 months on an injunction that the only thing the federal government was arguing was the Chevron deference. They can apply the word sanitation to people. That's not how it works, right? It's by context. And how many times have you seen Black's Law Dictionary used?
Never in legal writings. And so I warn people about that, and a lot of people try to disagree with me, but we've read too much to know that that's just not going to be valid.
Not one. And even though Steve Gardner, who writes them today, it's a good tool to use, but you don't go quoting that because everything's code pled. Where are you defining the words out of?
In the statute or
right.
Webster's 1828.
That's right. So to aid in this statutory interpretation, dictionaries provide only a helpful starting point, explaining that dictionary definitions will often fail to dictate what meaning a word must bear in a particular context. They give the broad sweep of what a word might mean, but not what it must mean in each context. So a huge point right here. See, Anthony Scalia and Brian A. Gardner, Reading Law, the Interpretation of Legal Text. Folks, I'm going to tell you where I got this book from was when I read this case law. And yes, it's a $60 book, but I gave y'all the free PDF. I like to hold mine. I like to make marks. I like to put tabs. I'm a book holder, so I like the real thing. This book will open your eyes to all of it and how it works. And it will also make you fundamentally resent how badly we've been educated. It's intentional. However, because common words typically have more than one meaning, you must use the context in which a given word appears to determine its test, most likely sense. There's a thread of common sense interpretations using logic and reason that most of the judicial branch has ignored with a direct goal of increasing state power, using theoretical prejudices of a particular philosophical bent. If we are to return to a common sense society, it will be because we reject these social engineers who use vagueness and ambiguity to increase the power of the state. One of the better case laws of all time is Chisholm versus Georgia. I'm sure most people have read it. One of the things that I missed in it, reading it the first few times, and I bought this man's book, by the way, but I just want to show the dichotomy between then and now and what has happened. James Wilson invoked Reed in the opening lines of the very first opinion to the report in the Supreme Court's Chisholm versus Georgia. Wilson noted that we were at the beginning of law under the new Constitution with no precedents to draw upon. We would have to look first at the general principles of jurisprudence, and yet even before that, he said, we have to be drawn back to Thomas Reed in his excellent inquiry into the human mind on the principles of common sense. Now, I will have to say this. I will just admit right now, I'm on the second reading of this book. This is the best philosophical book I've read to date. That's saying something, folks.
It absolutely is.
This is the best philosophical book I've ever read. And how he's not a well-known name, I understand. I knew when I went to buy this book, it was $78. I was like, okay, there.
We can't make this guy popular.
Mm-mm. No, which is to say the grounds on which we can reliably claim to know anything. Reed would appeal to those precepts of common sense that the ordinary man would know even before he could start trafficking in theories, but not only knew, they were the things he had to take for granted just to get on with the business of life. And so before the average man could start bantering with David Hume over the meaning of causation, he knew his own active powers to cause his own acts. So just remember that as you read an originalist and textualist, okay, they're accepting objective reality. Okay, that's the first thing. I just want people to understand. We are the minority in these courtrooms. We're the minority in the United. Well, I say that The vocal minority has control of all the airwaves, so we seem like we're the minority, but make no mistake about that. The truth is we're the majority. That's just the truth. So we'll go back to reading the case law, right? Start with the immediate context. Sanitation travels in company with inspection, fumigation, disinfection, pest extermination, and destruction. These terms involve measures aimed at identifying, isolating, and destroying the disease itself. And though sanitation is acceptable of multiple and wide-ranging meanings, it is given more precise content by the neighboring words with its associated. It's your associated words canon. What these words have in common is that they involve identifying and eliminating known sources of disease. Summarizing subsection A as government intrusions on property to sanitize and dispose of infected matter. They do not maintain the status of being disinfected or fumigated. Instead, they all change an object's status. More specifically, they involve the direct targeting of a disease through a discrete action.
Yeah, so it completely eliminates the problem, which is what is required for government to take action.
It must eliminate the evil that it purports exist. Okay, so let's draw the line. That's the Supreme Court case law. For them to come in and restrict your life, liberty, or property, or do the takings, eminent domain, it must eliminate the evil that it purports to exist. Okay, and they must have a persuasive damn argument first off. Then they need for the individual for public use and things of that nature. They got to have a persuasive argument, right? For the individual, they have to have material facts. Okay, there's another serious flaw to the masking and sanitation argument. Subsection A does not give the CD power to act on individuals directly. Oh, imagine that. Imagine that.
That's not what the CDC told me.
I know, right? And guess whose guidelines and recommendations to Virginia is that all healthcare workers have to have a influenza shot.
I might have to think about that one. The CDC?
Oh, and guess who owns all the flu shots?
The CDC?
Either the CDC or the DOD.
Yeah,
because you have to.
Yeah, it could have been the Department of Defense. I didn't know,
but they have to go through the CDC because you got to sign up for the same program, the Medicaid program that you had to sign up for COVID, and then you have to maintain your roster. So it's the same scheme. Okay. I tell you, hate such a strong word, but you do not despise these people enough. I'm telling you, these are outright rapscallions and scoundrels. Okay. Oh, rapscallion. How about that word?
Word of the day, folks. Word of the day.
All right. Reading the statute as a whole shows that it is divided into two parts. It is a fundamental canon of statutory construction that the words of a statute must be read in their context and with a view to their place in the overall statutory scheme. Quoting Davis versus Michigan Department of Treasury. The first subsection, A, gives the CD power to directly impose on an individual's property interest. The second part, subsection B through D, gives, remember, broad stroke, then it narrows it. Congress has delegated an authority to it, and then they've got to narrow. Genius species, right? Just remember that simple idea. The second part, subsections B through D, gives the CDC power to directly impose on an individual's liberty interest. See Tiger Lily. Dividing the statute in this manner, accord Tiger Lily. It's just a bunch of case law. I'm not going to read all that to you. Since the mask mandate regulates an individual's behavior, wearing a mask, it imposes directly on what interest?
Liberty.
Liberty. The right to think and act independently of anyone else. The right to hold beliefs contrary to popular opinion. The right to assume the risk of life. And we can go on and on ad nauseum. Not the property interest contemplated in subsection A. And that's the Chevron deference. So that is the document. And I told you we'll have 15, 20 minutes to go through here. If you haven't read this court case, I'd go read it in totality, because it goes into much further detail than what I just got the basics out of here, showing you that what we have went through the previous few studies to get to this point is very applicable. Okay. And if it's applicable, we should stick to these rules. We shouldn't deviate from them at all. Yet I'm not telling you you're going to walk into every courtroom and every judge is going to apply the rules of individualism, the rules of procedure, and the rules of the court. Folks, that's I'd be lying to you. I'd be lying to you. We got to get in front of an adult. There are adults in this system who can see what's going on and have had enough too.
And let me remind everyone that all these documents that we share on any, whether it be an interview or the instructional series, can all be found in our Telegram group. So go find the Big Sib chat and get in it. And then there's some subgroups in there that you're going to have to find links to. But we don't want to publicize that here. But if you get in there and ask somebody, or if you know how to find the links, you can certainly do that. And all of these documents are organized in a very searchable way. You can find exactly what you're looking for and read them all for yourselves, download them, share them, however you want to do it.
Yeah. And you know, even not just the documents, it's our motions, it's other people's motions, it's templates, get ideas. I have stuffed so much information into my head in the past 4 years that without being able to go back and read the documents again, we get a motion in, I got to go back and read the document again. Okay. I have to, because it's just so much. You can remember the first principles, right? And you can remember bits of a case law that you read here and there, and you know that it's in one of your memorandums. You got to go find it again. Gary and I, and if anybody out there can figure out a way to make a program or a file that we could separate all the case law in and search by keyword stroke, that would be so cool. You can do it in Telegram by word search. You'll find pretty much everything you word there, but I'd like to have it in a singular document with different tabs or something, or maybe there's even something new gadgety out there that I'm not aware of. Somebody was telling me about an Obsidian program the other day, but I got on it and I couldn't see exactly how to use it yet. I plan to go a little bit further into it.
Some people would say Westlaw does that for you.
Yeah, well, it does. Westlaw does make it easy.
It's just $400 a month.
Yeah, that's it. It's just a truck. Well, that's not a truck note anymore. That's probably a Pinto note. There is no greater impediment to the advancement of knowledge than the ambiguity of words. We are living in a time where they are telling us that snow is not cold, honey is not sweet. We are taking bitter for sweet, evil for good. Okay. This man was writing in the 1700s and they were doing the same thing. We think we live in a unique time period, but it's really the same. And I'll close off with this. Man is not fixable. Nature is innate and immutable. Okay. And as long as you have man, you have problems. If you accept that truth, when you accept it, what you'll do is you'll stand on your own 2 feet, being the best man or woman that you can be, and stand knowing that you've done all you could do up until that evil day. That's all we do. That's all we ask for. That's all we try to do. And with that, thank each and every one of you for stopping by today. We'll see you again next week. Probably deviate from the study. We're probably going to pull up a case law that Gary and I is working on and discuss different tactics or anything. I think I've shown y'all enough of the rules of statutory construction to give you a base foundation of the importance of it, right? And that it is applied in our courts, and it used to be applied in our courts all the time, okay? However, we got to get it back because the judicial branch is our branch.
Thank you, Brandon, for your time. Thank you all for being interested in these topics, and we will see you soon.